action includes recoupment, counterclaim, set-off, suit in equity, and any other proceeding in which rights are determined, including an action for possession. Abatement, a lease clause stating that if your apartment is damaged, not by your or someone in your care's fault or from a disaster, also known as force majeure, your landlord will allow you to suspend your lease and not charge you rent while the apartment is uninhabitable and you're living elsewhere. Accessible, an apartment that's able to be reached and occupied by a person with a physical disability. For a wheelchair user or person with mobility difficulty, this often includes lease or government-specified items like ramps and no steps, larger doors, adapted bathrooms, lowered light switches, and wide hallways. For people with hearing impairments, this might include doorbell and smoke alarm lamp signalers or bed shakers. For people with visual impairments, handrails and special lighting might be included. As a tenant, your lease may specify that you're accountable for keeping areas where wheelchairs may go free of items that can block the path or doorway, such as bicycles and trash cans. Application, a document. A potential tenant fills out so a landlord can decide if they're qualified to rent the apartment. In addition to basic information such as your workplace, social security number, and previous addresses, you may have to provide items such as pay stubs, bank statements, references, and recommendations. Arrears. When you're behind in your payments, whether it be late with rent or have a past due utility bill, you're in arrears. Building and housing codes include any law, ordinance, or governmental regulation concerning fitness for habitation, or the construction, maintenance, operation, occupancy, use, or the appearance of any premises or dwelling unit. Cosigner. A secondary, or more, signer of your lease who won't be residing in the apartment. A cosigner is usually used when the tenant has a short or poor rental or credit history and needs someone, usually a parent or employer, to vouch for them. This secondary person is equally responsible for upholding the terms of the lease as a backup if you cannot. Delivery of possession means returning dwelling unit keys to the landlord and vacating the premises. Dwelling unit. This means a structure or the part of a structure that is used as a home, residence, or sleeping place by one person who maintains a household, or by two or more persons who maintain a common household. Dwelling unit excludes real property used to accommodate a mobile home, unless the mobile home is rented or leased by the landlord. Eviction. The formal process where your landlord terminates your lease and asks you to vacate your apartment in a period of time decided by local laws and statutes. Good faith is honesty in fact in the conduct or transaction concerned. Guarantor. Similar to a cosigner, a guarantor is a third party who guarantees you'll pay your rent and fulfill your financial obligations as a renter. Landlord. This means the owner, lessor, or sublessor of the dwelling unit, or the building of which it is a part, and it also means a manager of the premises. Organization includes a corporation, government, governmental subdivision or agency, business trust, estate, trust, partnership or association, two or more persons having a joint or common interest, and any other legal or commercial entity which is a landlord, owner, manager, or constructive agent pursuant to Section 33, 113(22). Owner means one or more persons, jointly or severally, in whom is vested all or part of the legal title to property, or all or part of the beneficial ownership, and a right to present use and enjoyment of the premises. The term includes a mortgagee in possession. Person means an individual or organization. Premises means a dwelling unit and the structure of which it is a part, and existing facilities and appurtenances therein, including furniture and utilities where applicable, and grounds, areas, and existing facilities held out for the use of tenants generally, or whose use is promised to the tenant. Rent means payments to be made to the landlord in full consideration for the rented premises. Rental agreement means all agreements, written, oral, or implied by law, and valid rules and regulations adopted under Section 33, 1342, embodying the terms and conditions concerning the use and occupancy of a dwelling unit and premises. Roomer means a person occupying a dwelling unit that lacks a major bathroom or kitchen facility, in a structure where one or more major facilities are used in common by occupants of the dwelling unit and other dwelling units. The major facility in the case of a bathroom means toilet, or either a bath or shower, and in the case of a kitchen means a refrigerator, stove, or sink. Security deposit means money or property given to assure payment or performance under a rental agreement. Security does not include a reasonable charge for redecorating or cleaning. Single-family residence. This means a structure maintained and used as a single dwelling unit. Notwithstanding that a dwelling unit shares one or more walls with another dwelling unit, it is a single-family residence if it has direct access to a street or thoroughfare and shares neither heating facilities, hot water equipment, nor any other essential facility or service with any other dwelling unit. Tenant. This means a person entitled under a rental agreement to occupy a dwelling unit to the exclusion of others. Term of lease means the initial term or any renewal or extension of the written rental agreement currently in effect, not including any wrongful holdover period. Managing agent means a person, corporation, partnership, or limited liability company that is authorized by the owner to operate and manage the property. Residential rental property means property that is used solely as leased or rented property for residential purposes. If the property is a space rental mobile home park, the residential rental property includes the rental space that is leased or rented by the owner of that rental space, but does not include the mobile home or recreational vehicle that serves as the actual dwelling, if the dwelling is owned and occupied by the tenant of the rental space and not by the owner of the rental space. Slum property, a residential rental property that has deteriorated or is in a state of disrepair, and that manifests one or more of the following conditions that are a danger to the health or safety of the public. Structurally unsound exterior surfaces, roof, walls, doors, floors, stairwells, porches, or railings. Lack of potable water, adequate sanitation facilities, adequate water, or waste pipe connections. Hazardous electrical systems or gas connections. Lack of safe, rapid egress. Accumulation of human or animal waste, medical or biological waste, gaseous or combustible materials, dangerous or corrosive liquids, flammable or explosive materials, or drug paraphernalia. Mediation. This is a formal, and often legal, arbitration with an impartial third party employed to resolve disagreements between you and your landlord. Your lease may spell out conditions as to when mediation may be engaged, and who will do the mediating. Month to month. A rental agreement that's automatically renewed at the end of each month, as opposed to the end of the year or some other length, until ended by either party under the terms of the lease within a certain window of time. Notice to quit. A formal notice given to a tenant by the landlord stating he or she intends to end the lease and begin eviction. It will often state some cause that can be corrected, such as paying back owed rent or removing an illegal boarder, by a certain date to resolve the violation. Notice to vacate. A formal notice given to the landlord by a tenant stating he or she intends to end occupancy of the premises and not renew the lease. Your lease will usually state a window during which you can do this without penalty. Quiet enjoyment. A term often found in leases meaning you have an inherent right to peaceful and pleasurable use of your apartment within accepted standards. For example, this protects your basic rights to not have your landlord knocking on your door every day to bug you or having the lawn mowed at 4 a.m. Sublease. When a renter rents out part or all of an apartment to another person, you can rent out a single extra bedroom in your apartment or the entire place, either for a profit or because you'll be away for an extended period. But remember, you can't sublet your apartment without your landlord's permission, and you, as the primary leaseholder, are ultimately responsible for the rent getting to your landlord and for any actions or damage done by your subletter. Wear and tear. a term found in most leases that describes the acceptable amount of damage that does not trigger a monetary penalty deducted from your security deposit upon vacating the apartment. This takes the burden of responsibility away from the tenant for normal, unavoidable usage deterioration. Repainting and carpet cleaning, as well as damage such as chips, scuffs, and small scratches on cabinets, usually fall under acceptable or normal wear and tear.